Hello and welcome to Crane Talk, a podcast that covers all things cranes, rigging, and heavy iron. My name is Isaac Smith, and I'm joined by three experts in the field, Ron Thompson, Gene Greiner, and Laura Schoefer. How's everyone doing today?
Sir Isaac, we went from 70 degrees to 96. So we're getting into summertime here in Texas, and we had a lot of rainfall this spring and really early summer, and now nothing until mid-October. So hello, North Texas.
Yep.
Summer, it's back.
I miss having 4 seasons in the year. I'm from Kansas, where we'd have winter for a quarter of the year. I have winter for 2 weeks now.
Well, we get fall. Well, you see the memes of like all the stages of North Texas weather, and there's like, 7th level of hell.
Yes.
And then there's like, a little bit of a break, and then there's false fall, and then there's the 6th level of hell, and then there's a week of fall, and then you get ice, and then repeat,
and it goes right back.
So,
yeah, and also today's Friday, Wednesday night, we were standing out in our driveway about 9 o'clock, and I looked down. There's a little friendly copperhead snake.
Ooh, yeah, 5
feet from our feet. We go, oh, they're coming out because it's warm.
Yeah.
So they've been hibernating, but we have copperheads out where we live, and we try to stay away from them. Mm-hmm. So
same.
Yeah, it's hot. I was in Louisiana yesterday, and it was even muggier there. So just buckle down, get ready, stay in the air conditioning. It's rough. So,
Ron, do you want to introduce our guest today?
Yeah, be glad to. Laura Schoefer, we've been trying to get as a guest for quite some time. She is claims specialist at Dual, and I got to know her, and let me tell you, she's crackerjack sharp. And one of the oddities here is Laura has her Juris Doctorate. I mean, she is a lawyer. And when you see lawyers coming over to the dark side, no, I'm just kidding. When you see lawyers coming over to do the claims litigation management, it brings the levels up because this industry, we deal with a lot of plaintiff counsel, deal with defense counsel. And I think Laura got her JD from Northeastern. Is that correct, Laura?
That's right.
Okay. And looking at Laura's resume, did you work for the SEC?
I did. Ron, you did your research.
Tell us about that.
Sure. So I always wanted to be a lawyer. I was 8 years old, and I would tell you, I'm going to be a lawyer. And I was one of those kids who didn't think that being a lawyer was arguing all day. I knew it was reading and writing, and I still thought that was compelling. So I also went to Northeastern for undergrad. They have a co-op program. So I worked at a large law firm at like 19 years old, doing complex security litigation at a very low level. And I fell in love with it. And I thought, I'm going to grow up and be a securities attorney. And so all throughout law school, I focused my internships on securities law, different machinations of it, worked at the SEC, like you're saying, which is the governing body for securities law, and hated it because there was no real push there. They really didn't want you to do a ton of work. There was a mechanism where you could unregister traders who were clearly doing pump and dump schemes where they're trying to inflate the value of a stock to sell it off and pocket. And these are over-the-counter trades, so not registered. It's only fraud. It's just a cesspool of fraud. And so I was very motivated, wanted to unregister all of these traders. And they were like, whoa. Let's slow down a little bit. Let's not do so much. How about if you only do like 5 a day? I was cranking out like 30 plus a day. And so I quickly realized that government work perhaps isn't for me, at least at that time.
So tell us a little bit how did you get over to the carrier program insurance side for the claims end of it? I'm just curious how'd that career path go for you?
Sure. So I had focused all of my experience on securities litigation. It became clear that wasn't going to happen. I graduated during a tough economy, and there just weren't entry-level security lawyer jobs out there. So I was fortunate enough to land with a big self-insured working on their environmental liabilities. And again, I like a quicker pace, working a harder day than perhaps was going on there. And so the gentleman who had sat next to me for a year went to Berkshire Hathaway's claim shop and said, hey, it's not great, but it's better than this. Why don't you come with me? And, you're young, so you'll move for $5,000. It doesn't have to be so promising, and he'll make a move. So I followed him to Berkshire Hathaway, and that's where I fell in love with claims, where I really learned what it looked like to work on complex litigated claims. I did a lot of asbestos claims. So you're talking nationwide exposure, tens of thousands, sometimes hundreds of thousands of claims, and you're really working with a few core policyholders to make a difference in these companies, if they're going to be able to survive or not. And so I spent a ton of time at Berkshire, had a brief stint away as a coverage attorney just to have that real firm experience, quickly came back to Berkshire. And then my leader was leaving Berkshire to go to Allianz and said, come with me, you can be the technical director for runoff claims at Allianz. And that was compelling to me, got me out of the individual contributor capacity. So I went with her and served as the technical director for Allianz, working on a variety of claims, really honing my litigation management skills, coverage skills, entered leadership at that time. And because it was runoff, the more successful you are at your job, the claims universe gets smaller, not bigger. And so 5 years into it, my job was smaller than it was at the onset. And I had just had my second child. And I thought, I'm going to be away from my kids all day. It has to be for something real, right? Something that's engaging. So on a whim, one night, I applied to a startup, an excess casualty startup that wasn't writing business yet, didn't have a single claim, hadn't issued a single insurance policy. And the woman who was running the startup emailed me by 5:30 the next morning, let's meet. And I loved her, loved what she was doing. And I left super stable carrier, top level Allianz to go to this insurtech startup. And I used my brain in all these interesting different ways. I was the only lawyer there. I did their carrier partner agreement, the reinsurance treaty, everything you could think of. And after a while the program had started up successfully and we did write business, it was clear they wouldn't need somebody like me for quite a long time. So then I pivoted and then ultimately was at what was formerly NBIS, now Dual Specialty Construction and Transport.
Well, it's awesome. I can personally say Laura's helped me. When you said coverage lawyer, well, all of our ears popped up because when there's a complicated claim, sometimes it goes to coverage lawyers for the carrier because they want to make sure they're interpreting the coverage intent properly. Laura's been awesome in supporting what we're doing as far as the coverage things. And it's good to have a lawyer talking to lawyers. And before we get into that, have you ever been to the Grand O Fish Fry at the Thomas Reading Herring Run Park? That is an annual event that they bring out the herring. I don't think they use herring anymore, but it is in Pembroke. It's a historic town, halfway between Boston and Cape Cod. So is that kind of where you're...
Ron, I'm laughing to myself because that is 2 minutes from my house and it is a very big deal in my town. So it's this little park with a brook that kind of runs through it. And then at a certain time of year, the herring run through the brook and then they do a big fish fry and it's like a very big town event.
I thought I'd connect with you with that statement. I go... I'm going to see where Pembroke is. And then I started reading some of the events that take place, and I'm going to throw it out to Laura, see if she connects with that. I appreciate that. We're going to get into some subject matter here. 3 or 4 items that we pop up every day, and Laura deals with this daily. And the first subject, Laura, I want you to expand on, is the good old Stowers demand, also known as a hammer letter, that we get quite often. Why don't you go ahead and tell us a little bit about that Stowers doctrine?
Sure. So Stowers doctrine is specific to Texas. So that's probably why you guys want to chat through it. But there's different iterations of it nationwide. In Georgia, it's called a Holt demand. If you were in West Virginia, it would be called a Shamblin demand. But basically, it's a demand that a plaintiff's attorney would issue to an insurance company or potentially to a defendant themselves saying, I want to resolve the claim against you. You have X number of days to resolve the claim. And they have become unbelievably common in recent years.
One of the questions I get, it puts pressure on the primary carrier to go ahead and settle within policy limits, usually $1 million primary limit. The question I'm getting now, Laura, is when we have umbrella towers, we have umbrella limits, let's say up to $20 million, and there's 5 or 6 different umbrella excess carriers over that primary $1 million limit. How does that work when you get a Stour, well, I'm going to call it a hammer letter, when you have layers of excess carriers building up to the 20 million, how does that work?
So it can be fascinating, Ron, because what we're seeing right now is that plaintiffs' counsel feels so much pressure on them to get a demand out quickly that they actually aren't demanding a specific number. So sometimes they'll say, I'll settle your case if you give me $5 million. But more often than not, what we're seeing is they don't know what the insurance tower looks like. And so they say, I'll settle your case for policy limits. And what does that mean? Does that mean the million primary, or does it mean if you have a $10 million tower, are they looking for the full $10 million? And so the onus is on the primary layer to really thoughtfully respond to the case, disclose what their limits are, what might be remaining potentially, depending where you are, both in the country and in terms of litigation. But what you're trying to do ultimately is get plaintiffs' counsel to say a specific number that they are looking for. And then if it's in excess of the primary layer, they can only say either I'm rejecting the demand because it's excessive, or I can't accept the demand, but I can accept my portion of the demand. And then they would notify the excess carrier and potentially tender their limits. And that's where the concept of a hammer letter really comes into place, because the demand from plaintiffs' counsel is the Stours or the Holt or the Tiger River, whatever machination it takes depending on your jurisdiction. But then the hammer could potentially come in if, let's say, we have a scenario where they want $2 million and the primary says it's definitely worth more than my million. So yes, I'm going to accept vis-a-vis my policy. And then let's say your excess carrier doesn't want to accept or is slow to accept. Either the insured themselves or the primary carrier could, quote, hammer the excess carrier. And what that looks like is sending a letter saying, we believe you should resolve this case in good faith within policy limits. And what happens for the excess carrier is if they have been hammered and they don't accept the demand, and then ultimately there's a verdict in excess of the $2 million, that excess carrier may potentially have to cover the verdict even if it's beyond policy limits. So let's say they don't take the $2 million, they've been hammered, and a $20 million judgment comes out, that excess carrier may potentially be on the hook for the full verdict.
Okay, so it incentivizes excess carriers to negotiate in good faith, but also incentive to go ahead and settle, because the potential of a big verdict going way beyond, say, their $2 million limit. And that's an issue. That's a really big advantage for plaintiff lawyers.
It is. And so one reason why I think they've become so popular lately is a book was written called Running with the Bulls, How to Win Top Dollar Settlements. And it was written by Nick Rowley, which is a famous plaintiff's attorney in California from the Rowley Law Firm. And he claims to have won $3.5 billion in judgments for his clients. And in this book, I won't buy the book because it's $185, and I refuse to give a plaintiff's lawyer $185 of my own dollars. But I understand he suggests that it's essentially malpractice if, as a plaintiff's lawyer, you don't make a time limit demand at some point in the case. So that's why you see these demands kind of frenetically coming out in almost every single case is, oh, I have an obligation to my client, I better put out a time limit demand. But in reality, there's only so much time in the day, and these letters have to be responded to. And so sending out letters for insane values that you yourself never are looking for in the case just ties up adjuster time that could actually be spent evaluating your case and making a reasonable settlement offer. So I personally think these time limit demands have utility, but are bad for the industry and can at times slow up resolution rather than facilitating it.
Well, we're thinking here, with the umbrella market being very tight, I mean, there's limited amount of capacity to insure a heavy construction account. And if you have a $20 million umbrella sitting on top of your $1 million primary GL limit, you may have 5 or 6 different insurance companies that's building up that $20 million tower. So with Stowers, I would say that would be a crazy trying to manage 5 different opinions on the strategy on how to settle a case or not settle a case.
It can get problematic. Oftentimes you can see the exposure is de minimis and it should settle within the primary. Or I think this is a $5 million case. So the primary puts up their limit and the first layer excess puts up their limit. But where I think it gets significantly harder is in that $15 to $25 million range. I think there's a lot of subjectivity there around fatalities with people of a certain age. Do you think it's more on the low end? Do you think it's more on the high end? And that's where I think you tend to see a lot of valuation disputes, is really trying to hone in on the worth of those claims.
Yeah. Gene, you've been Stowered before on a couple of your clients.
Well, and it's unpopular for the client, the insured as well, because the sentiment from them is fight. Like we want the carrier to get after them. But when there's infighting between the umbrella carriers on valuation disputes and these types of things, or maybe a hammer letter coming from a higher level carrier down to a lower level carrier, that might cause the carrier to want to settle or go ahead and accept the demand. And then, you and I have to deliver the bad news. Yeah, it's unpopular. The insurance carrier gets the blame, but the statute and how it's being used is really the breeding ground for all of the consternation, right? And so, yeah, I mean, it can be very frustrating on this side of the table. I know it is for them, for sure, but what do we say? It's like taking a butter knife to a gunfight, right? When you're trying to deal with all of this and align the defense and align the insured and align the agency and all the carriers that are in play.
And from a carrier standpoint or program standpoint, you get well-funded plaintiff lawyers funded by third-party litigation, and they're bringing in top-quality doctors to testify, top-quality forensic recreation experts. Laura, you deal with this all the time. From your vantage point, when they bring in these high-powered expert witnesses, how do you guys combat? Do you go out and bring your own high-powered experts in?
I think you have to be really thoughtful there and think about the case and do it on a case-by-case basis. There's certainly some jurisdictions, New York in particular, where they're looking for that battle of the experts. And if you have one high-flying expert on one side, you want to counter that with the same level on the other side. But then I actually find in different jurisdictions, Texas potentially being one of them, depending on the county, where a very expensive expert kind of plays like that. And pragmatists can see this is a hired gun. This person spent no time with the claimant. They never met them in person, or they met them one time. And then we really try to draw out testimony around how much were you compensated for your appearance in court today? And how much time did you spend with this person to give your opinion? And, in some jurisdictions that plays really well. So knowing your jury pool and what potentially resonates with them and making decisions accordingly is a big part of the strategy.
So your job is very, very mundane. Everything is the same day in and day out. I'm being very facetious. Laura, you're in a very exciting field of the claims management business. It's higher hazard, heavy construction type accounts, and you see it all. The pain right now is where rubber meets the road. Anything locomotion over the road, we get quick representation from plaintiff attorneys. We've talked about extensively on our podcast about case runners getting this information to a plaintiff lawyer within hours.
Yeah.
So your job's cut out.
I had one recently, just a few weeks ago, where an accident in Texas, and the other party got out of the vehicle, and before he called his family, before he called his wife, his kids, he had his attorney on the line. And so our customer, our insured, called me and said, hey, this is odd. There's a guy that is on the scene of the accident, and he has his cell phone to the ear of the police officer because he wants the police officer to talk to his attorney on the scene in hopes that somehow the attorney could maybe, talk to the police. And this gets into the police report or whatever. So we had to pivot and do the same thing. So our customer downloaded their dash cam video, texted it to the driver of our truck, and showed it to the police officer. And luckily, the police officer was really annoyed that the guy put his attorney on the phone and put it up to his ear. We have a pretty solid, case on that one. But yeah, it's like he didn't call for anybody else but his attorney at that moment. Just got in an accident, and he's like, plaintiff counsel, please help me in this situation. It's I don't know. It's crazy. That's a little quick, almost as if it was, maybe he was planning on it. I don't know. We'll see.
Well, video is a great truth teller.
Yes, it is.
So I want to move on to another topic. And we've talked about this too on our podcast, the borrowed servant doctrine. And there was a big case here in Texas back in 2019. A tower crane collapsed. Laura, I want to talk to you about, are you guys using borrowed servant for defense on certain cases?
We are. So we actually are using borrowed servant in a couple different ways, factually in specific claims where it makes sense to do so. And we can talk about that more, but also at dual specialty construction and transport, we really have unprecedented loss control assistance for our policyholders. And so as part of our service, we will work with the policyholder to get their contracts set up so that they are in a great place to make borrowed servant arguments or protect themselves against borrowed servant arguments, depending upon the context of their work. And so that can be very helpful before a claim even originates, just going to market, knowing that you have your rental ticket or whatever your contracts are in order so that you're prepared to protect yourself in the event of a claim. So we're using it offensively and defensively.
You want to dig a little bit deeper in the woods and explain what borrowed servant is?
Absolutely. I actually was fortunate enough to just write an article about it in May for American Crane and Transport magazine. So I'm thankful to the SCNRA for that opportunity. But it's a legal concept, so try to bear with me. I know nobody wants to talk too much about legal things, but it really can be material for your loss run, so it is important. The concept is generally a basic one. You are an employee of one employer, the general employer, but you are, through any mechanism, working for another employer, the special employer, and the special employer controls how you do your work and what work you're doing. If something happens as a result of your work for the special employer may be responsible for the economic consequences of that instead of your general employer. So the key part of the analysis is control. Who was controlling your work at the time of an accident or whatever event took place causing damage?
Now, why is that a big deal? Well, the big deal, it moves an employee from one employer to the special employer, triggered by how the special employer has control and supervision over the employee that's actually from another company. And from liability standpoint, that would be huge in shifting the responsibility over to the special employer. Is that correct, Laura?
It is. And it controls who pays and then potentially how they pay as well, because there's also an intersection with the workers' compensation and workers' comp being the exclusive remedy for injuries to employees. So let's say, Ron, that you worked for Gene. You are Gene's employee, but Gene sends you over to work for me for the day. And I control everything that you do and what you're doing. If you then injure my other employee, Sarah, that becomes a workers' comp matter where Sarah would file against my workers' comp insurance if borrowed servant applied. Otherwise, it would be a tort matter because you're Jean's employee and Sarah would be able to sue Jean's company in the tort system. So that really is a significant factor.
Laura, is there like litmus tests surrounding the idea of control? What are the check boxes that say, okay, they may be saying contractually that this is a borrowed servant, but are they actually a borrowed servant? Are there any like statutory check boxes that show the rule, if you will?
That's a great question, Jean. I think about, have you guys seen those TikToks that have become kind of viral right now where one person says perkily, I wanted sushi. And the other person says, I wanted a burger. And then they say, we compromised and got sushi. And you're like, is that control? The person who got the sushi? So in this context, it's about what is being done and how it's being done. You want the special employer to be controlling the what and the how. And it wouldn't be this podcast if we didn't talk about Billy Smith a little bit because of his unbelievable service, both to Dual and the crane industry overall. I have to say something shocking. Billy did not invent borrowed servant, but he did advocate for it more than anybody out there potentially. But there's this 1951 case called Nepstad. It's from Minnesota, and it describes the level of control. And it characterizes the crane operator as essentially being an automatic eye, which caused the machinery of the crane to respond to the signals given by the company. So that's what you want to see, where there's essentially no independent judgment. You're just carrying out the instructions of the special employer. And so what you're looking for is the contract language to support that, but then also prospective deposition testimony that would confirm it actually happened like that. So it's not enough for the contract to say you're going to be in charge of everything. Then when the day occurs, the special employer has to actually be taking charge like that and be providing the directions and the borrowed servant responding accordingly.
So like means and methods, maybe the special employer is controlling that borrowed servant's paid time off, these types of things.
Right to discharge.
Right to discharge. Yeah.
So it triggers certain things. Are you asserting the borrowed servant doctrine? Just depends on the case. You're doing it more or less, or is it being kicked back? Wait, we're not going to. The plaintiff's side saying that's not borrowed servant. Is there a lot of back and forth on that?
There's certainly a lot of back and forth on that. The plaintiff's bar is going to be looking for any time that the special employer wasn't potentially in full control of things. And so given the nature of this work, there can always be ambiguity because let's say you, as the general employer, provided a crane and an operator at a site. The argument that we see all the time is even if the special employer said, you're at this site on this day, at this time, you're going to pick this up and you're going to put it here and I'm going to signal you through the entire process. The argument that we hear all the time is, but they could have said no. They could have refused to pick it up. They could have refused to put it down there. And in most jurisdictions, the could have isn't enough. It's that, oh, and then one time they didn't do so, or they were being signaled by one of their own fellow employees, not exclusively the special employer. Things like that can muddy the waters of the analysis.
So if you get into, the rental agreement or the work order or work ticket that the crane companies use, and speaking of Dual, I mean, they have preferred language in their rental agreements. It addresses a lot of this stuff. So you may address maybe triggers of a borrowed servant based on use of equipment. But on the other side, Laura, the crane companies get MSAs, master service agreements, which puts all the blame and responsibility on the crane company. So we're not lawyers. We try to alert and educate our clients about certain things in that MSA. So you have a really well-written rental agreement, from the crane company, and then they've signed a master service agreement that's saying all the responsibilities are back on crane company. You're a true subcontractor. We have no control over you. So they're addressing in that MSA some of the things saying we're not going to be the special employer on this. So you have the rental contract versus their MSA, and you have two different versions. So I know there's statutes, I know there's B30.5 OSHA regulations that we could use for defense, but when you have MSA saying we're not, and then a rental agreement saying, yeah, you are a board servant, do you get that quite a bit?
We do. And so we try to work with our insureds to think creatively around the MSAs and, can they limit some of the language there? Can you add in a provision in the MSA that says, but for other language to the contrary, kind of making room for the rental ticket to supersede. You can also put on your rental ticket, this document supersedes all past contracts to the extent it is inconsistent with same. So there are contractual approaches that you can take to try to protect yourself in this context, but certainly this is an area where you can muddy the waters and everybody wants work, everybody's trying to make money, but thinking through when you're signing these MSAs, what is that doing and what kind of risk is that putting on you? Is it worth it to you? And trying to work through that.
So if the daily rental agreement was signed maybe the day of an accident, and then an MSA was signed, 10, 11 months prior, if the rental agreement has kind of equal and opposite language, to what you were talking about, anything prior, this supersedes that, like the timeliness of the daily rental agreement gives you a leg to stand on at least, or at least that's what you guys are trying to fight for, in that scenario.
Absolutely. Using what we can to protect the policyholder's best interests. We're
going to go on to another topic. And I'm not really sure about this one. Laura, you're going to be a real big support on this one. Named insured considerations. Talk to us a little bit about that.
Yeah. So, from your work, insurance, we're in a hard market when we talk about the casualty space. The premiums are expensive. There are significant insureds that everybody can identify that have sold off portions of their business because they simply can't afford to insure it. And so when you think about how can you control your premium, you being relentless around named insureds and who you add to your policy is one way of doing that. So, going back to your earlier point, you're trying to do work, you're approached by an entity and they're willing to give you some good business, but as part of the MSA, maybe it says you have to add me to your insurance policy as a named insured. That means they can access your insurance policy. And if you think about it, they want that because they get defense and indemnity in the event of a claim. There may be no need for their own insurance or more limited insurance profile because they have the benefit of this other insurance profile. From your point of view, you have to be thinking about this entity can now erode my limits. I'm paying the premium for it, and we could potentially have coverage disputes if I don't think they should be covered for this claim on the policy, but they're on there. And so there's a couple of strategies here that you want to think about. One of them is the distinction between being a named insured and being an additional insured. So additional insured status is typically seen by an ISO form. It's the CG 2010, and it uses caused by language. And so that limits the entity's ability to access your insurance policy to a clear causal link between the accident and the liability for coverage. So let's say Ron wants to be on my insurance policy as a named insured. We're both at the same site, and then 2 years later, we get a blind lawsuit in. Ron's tendering that to me, and at least his defense is most likely going to be picked up by my insurance policy. So now, if we spend $50,000 defending Ron in this lawsuit, it's $50,000 on my loss run. I'm paying the premium consequences of that for the next 5 years. Versus if I put Ron on my policy as an additional insured, and it turns out he was sued in this blind lawsuit, but it's from work at a different part of the site that has nothing to do with his work for me, I'm not picking that up and I'm not living with that exposure for the next 5 years. And so thinking through when somebody says, I want NI status, countering, how about AI status? That is potentially a compromise that could provide your insured a little bit more protection.
Additional insured also is supported by Texas statute on the indemnity laws. And indemnity laws says you're responsible for acts of negligence caused by. You get into a named insured situation, it could be an arising out of, which really piggybacks our clients' insurance policies as a named insured. So when we talk about that, I said, we go back to the Texas Insurance Code. The statute here reads caused by, not arising out of. And arising out of language means you're sitting out there in a porta potty and a claim happens and you're blamed. It's arising. Arising or connected to, and that language is
a rough visit to the porta potty.
We had that happen.
Yeah, really?
Yeah, and we were named because we were using porta potty. So, very important. And when we get requests for additional insureds, it's usually not one our named insureds. It's a laundry list of named insureds. Well, it's like 5 they want to add as a named insured.
You bring up a really good point too about the dilutive effect of all of this, and you've also mentioned, we all know the insurance marketplace is a disaster right now. It is extremely hard, and the excess market is some of the hardest insurance to place, right? And so, if you end up with a claim because of this named insured type situation, and your carrier's, paying a claim on it, it's diluting your limits, it just makes it harder for you to find to the level of insurance limit that you had prior. A lot of people are lowering their limits right now, and so the dilutive effect is even greater. If you used to be running 20 and now you're running 10, or if you were running 10 and now you're running 5, it's the little things in advance and the negotiations of those requests from the customer base is, I wouldn't say it's like an immediate fix, but it's something you can be proactive about, and over time, it should have a nice impact on unrealized claims, unrealized expense, unrealized premium, because it just never happened, right? You set up the dominoes to fall where you can defend yourself. It's not something that pays dividends just immediately, but when the claim happens, it's there, it's ready.
Yeah. And so what we're seeing now is these large verdicts make headlines. I think there was a large verdict here in Texas just several weeks ago, $650 million. The tower crane, there was a verdict, $865 million. And those make headlines. So we're seeing requests for higher limits of umbrellas in a very tight umbrella market where capacity is limited. So if our clients are reducing their limits because of cost, we're getting more requests on saying we want higher limits. So it's a predicament that's caught between their customer base requiring higher limits, and they've just lowered their limits because of the premium. And that's a kind of conundrum we're dealing with right now.
Yeah, just this spring, we've had several come in for 25 mil, and that's not the norm, right? But we had like 4 or 5 just like a month or 2 ago. And it was like bam, bam, bam. It's like everybody got together and said, you know what we're going to do? We're going to go for 25 million. That's what we need these crane guys to get. And getting the 25 mil is hard because of this, The excess carriers are not, they don't they don't want to pay out $25 million,
Well, none of the excess carriers want to be the lead. Like if you have $1 million liability policy, getting that first $2 million in excess of the one is hard.
Yep.
Because nobody wants to be in that first $3 million deal.
Nope.
And then they'll put up 2 where before they put up 5 or 10.
Yeah, that's the hot corner, right?
Yeah.
Yeah, they're coming at you hard and fast right after the primary.
Topic that's been really hot in the headlines the last 2 or 3 months, and it's a big T word called tariffs. Laura, I want you to talk a little bit about how tariffs are affecting some of the cost, especially on first-party coverages like the value of equipment.
Yeah, I would be happy to. I think if anybody tells you they know the answer to tariffs, they're full of it. But everybody wants to talk about it, certainly. And I think about it from a couple different standpoints, but one of them being your equipment schedule and really thinking through how you want to value some of this equipment vis-a-vis stated value. So let's say you just bought a piece of equipment for $100,000. What impact do you think tariffs is going to have on your business? Where did that piece of equipment come from? If you have to replace that equipment during the policy year, is it going to cost you $120,000 to do so? If it is, or if you're genuinely concerned that it could be, which I think is a realistic concern, do you want to schedule it at 120 right now going into the policy period? Are you in a position to take that delta if it does go up to 120,000, but you scheduled it at 100, or before you used to be a little aggressive, and so you scheduled it at 90? Talking to you, this is where I think you guys can do some of your best work in advising your clients. Okay, this is what your equipment looks like. This is what the future could look like. Like, how are you economically situated to sustain a loss? Are you okay with the potential downside of equipment costing more, or do we want to insure it differently right now?
The tariffs change daily. I think Germany and Japan are big markets for our crane people. Bauma was a huge construction convention in Munich, Germany, maybe a month or two ago. And Liebherr is a huge German manufacturer of cranes. It was their big trade show. Bauma's like ConExpo on steroids. It's like 3 to 4 times larger than ConExpo in Las Vegas. And it happens every
4 years.
Every 4 years.
Yeah.
And so the tariffs came down right when that Bauma convention was kicking off. And I was curious, how do you buy a machine, a German-made machine, not knowing if the tariffs are going to go up, down, sideways? And I think Germany's part of the EU, and I think it's 10% as we talk today. It may change. And Japan is 24% on construction equipment. So you're right, Laura. If you spend $1 million January 1st, it could be $1,250,000 right now if you buy a new machine that's manufactured in Japan. And secondly, those parts are coming from Germany and Japan, and now the parts you buy are up 24 or 10 based on what the tariffs are for that current deal. So it's a huge deal, and it's a moving target. I think the latest 2 tariffs are going to be in effect July 9th, the 10 for EU and 24 on construction equipment for Japan. So that's a great thing for us. I'm not going to get too deep, but we don't want to get into any co-insurance issues where there is a
threshold.
Yeah, where the value is lower than what we had scheduled.
Yeah, because somebody could be completely honest and say 6 months ago, I bought this unit for this price, right? They're not devaluing it. They're giving the insurance company just the information, but subsequently after adding that equipment, if you're outside of the bounds of the co-insurance percentage, then the carrier will penalize you on the claim. And it could be big.
Yeah,
so,
a lot of our clients are saying, well, it's $1 million, but I had to pay tariffs $1,250,000.
Yeah.
And it still may be $1 million on the policy.
Right.
And then you have, unfortunately, a total loss, and then it becomes problematic. Sort of like COVID, Gene. Remember when used pickup trucks doubled in price?
Yeah. Yeah. Sure.
And our clients were on a stated value where, we insured for $50,000. Well, they total out,
90
grand. They're going, wait, what? We have 50,000. So the COVID effect also influenced the valuation of first-party claims.
Yeah, I would also encourage people to think about how their work and their main customers' work might change slightly in preparation for tariffs. I know some folks with buying power, if they know they always get their cranes from Liebherr and they always need these kinds of parts, maybe they've just proactively purchased equipment because they don't want to be dealing with a future tariff. If you're holding something for one of your clients, you need to think about your warehouseman exposure. Do you have warehouseman coverage? Warehouseman typically requires a receipt. So making sure that you've gotten that. And then cargo and transport, if you're trying to say, oh no, I was really transporting it and I was just storing it in transport, that normally has a 60-day threshold. But if you're kind of holding on to things a little bit because of a concern about tariffs, just being mindful of those potential exposures, I think we'll see more and more of as people are, I know myself, the night before tariffs were allegedly kicking in with Canada, I bought a huge thing of paper towels and a huge thing of toilet paper. So I've been sitting on that. But, what are you sitting on? What happens in the event of a loss because of that?
That's a great point on warehousing and transit. Like the bill of lading is devalued due to the potential loss if it were to be damaged.
So really evaluating the values of the equipment, their pickup trucks or tractor units, anything that could be maybe have imported parts could also increase. And then just the delay of getting parts.
Yep, for sure.
So interesting topic. So Laura, it's been a fascinating interview. I wish we could hire you, but Dual wouldn't like that very much. So what does Laura Schoefer do when you're not 100,000 miles deep in these the claim litigation end of it? I know you have kids.
That's the answer, Ron. Mom life. I have a newly 4-year-old little boy, Camden. I have a 5-year-old little girl, Madison. And I have a 16-year-old, Cole. So I'm working at this night and day, or I'm trying to be the best mom I can be. We just started summer vacation here. So this is my first week of trying to deal with camp drop-offs. And you never appreciated the school bus so much as that first week of summer with the absurd camp start times.
Does a 16-year-old act as a chauffeur?
So he doesn't have his license yet. In Massachusetts, it's like you get your permit and then you have to go through driver's ed and have a delay time. And so that's his big summer goal, is to get his license. If all goes well this weekend, we will be picking up a 2004 Subaru Outback, which will be his first car. And we'll see by the end of the summer if I can answer a little differently.
You make it over to Cape Cod?
I do. So he actually, the big guy's my stepson. He lives on the very top of Cape Cod. So I am there very regularly.
That's awesome. Is the traffic bad getting to Cape Cod from your place?
Horrible. Everywhere in the country will tell you they have bad traffic. Dual Specialty is headquartered in Atlanta. Atlanta thinks it has bad traffic. Different places say bad traffic. You haven't seen traffic like trying to get to Cape Cod on a sunny Friday afternoon.
It's Friday afternoon, Laura. How about a little trip to Cape Cod?
I would love to see you. Come on up, Ron.
Well, you've been awesome. We learned a lot from you. And when I first met you, I was impressed just with your legal background. And in this business, you deal with lawyers all the time on both plaintiff and defense side. And to run things by Laura has been huge, and I appreciate that. Gene, we always talk about your tribe. This has been well documented. Gene's got triplets. Gene, talk to us about what your summer is.
So we're in summer now too, and just like you, it is a direct and inverse force on productivity and scheduling. Because, oh my gosh, what are we going to do with these kids? But they're big baseball guys, and so they're in all the little camps and all that kind of stuff. But yeah, we're fighting that as well. We had all of our babysitters graduated this year, so we are completely bummed. They're all moving on to college, and so we had to go on a full court press to find the next wave of babysitters and plead with them to come spend time with us this summer. My wife works as well, and so we're always just scrambling. It's a mess. But yeah, so I can understand. And our Cape Cod is Lake Ray Hubbard. The bridge is completely torn up across the lake to get in our suburb east of Dallas, and it's a point of contention. So I can sympathize with the traffic troubles. It's terrible. So
Gene and myself took a trip to, I think it was Texas Craner Association in Houston, and so I get to ride in his excursion.
Hey,
This is a 2003 excursion, Gene?
yeah, 2003 excursion. We're going backwards. We like cars that are 100% depreciated. And with triplet boys, I thought, what got a good deal on this old truck. What better car for them to have at 16 rather than a 12,000 pound SUV that doesn't go very fast, and if they get in an accident, they'll win. So I love that old truck. We call it the war wagon in our family, and I think it's appropriately named. Ron and I drove to Houston in this thing, and I think by the end of the trip, both of us had hearing damage, sore backs. It's larger than life, but deep down, I really like it.
Well, this is what's fun is Gene and myself, in this business, we're on the phone quite a bit. And so we would take turns calling or returning phone calls because you can't talk the same time in the excursion, especially with the outside noise coming in. So I'd get through and I go, your turn. And he'd make a phone call and he'd get through his phone call and he goes, I said, do you have another one coming up? He goes, not for 20 minutes. Then I'd get on the phone.
There you go.
So we back and forth that thing for 4.5 hours.
I'm assuming the Subaru is going to be way more comfortable than the war wagon. So good choice on your part.
Thank you. I think same philosophy is let's have somebody else take that depreciation. And when the inevitable first little car accident happens, nobody's going to be too upset about it.
Nope. I agree. I love it. A depreciated car is the best kind of car.
Absolutely.
So,
well, I always end with, I'm a wannabe film critic, but since we're talking this time of year, is your favorite all-time baseball movie? And,
okay.
And so I do have a couple. Most people are going to go Bull Durham or The Sandlot, but two of my favorites are The Natural with Robert Redford and Field of Dreams with Kevin Costner. And I can watch that all day long. A League of Their Own was awesome. Tom Hanks, the all-women's baseball team during World War II. But if you hadn't caught Field of Dreams or the Natural, I mean, those are classics. So
you'll like this. So my boys are into baseball. They're in 10U Little League baseball, and they are all in. I mean, we've got accessories. We've got elbow protectors, sliding mitts. I mean, these bats that they swing are like car payments. It's ridiculous. So you know what? We like there's a little pressure there to perform. They think they're little, little Derek Jeters or whatever. But anyway, when we have a tournament on the weekends, that's what I wake them up to is the soundtrack to The Natural.
Oh, really?
Yeah.
Awesome.
Yeah.
Roy Dobbs.
Yeah. So the soundtrack to The Natural, there's the main hook, the main theme is also what they play at Ranger Stadium when they hit a home run.
You're kidding me.
Yeah. And so 6 o'clock in the morning, Saturday morning, dun, 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 dun. The whole house is like, Dad, not again. I'm like, well, I love it. I'm like, now I'm getting pumped up. So, yeah.
Well, and in Field of Dreams, if I had a tear because, he saw his dad,
Yeah.
playing catch with him.
Of course.
But anyway, hey, great interview, Laura. You're fabulous. We learn a lot from you. Our listeners will learn a lot from this podcast. So I want to thank you very much and enjoy the weekend and good luck with that 16-year-old vehicle you're going to get for your son. So
I'm so glad that you said A League of Their Own because that's my favorite baseball movie. And there's a part in there where Tom Hanks says it's the hard that makes it great. And I feel that way about claims. It's the hard that makes it great. So it was such a privilege to be here and talk about some claim scenarios with you. Thank you for having me.
You're very passionate, and Dual is very lucky to have you on board. So it's been great talking to you.
All right. Well, with that, thank you for listening, and be sure that you subscribe and leave us a 5-star review. If you have any questions, you could reach out to us by following the links in the show notes down below. New episodes come out each month, and we will see you next time.